Hi, I'm Matt Drake of Drake QS Limited. This series of podcasts concerns do-it-yourself construction adjudication. In this series, you'll hear information from Peter Vinden, the Chief Executive of the Vinden Partnership, Paul Jensen, the Principal at Paul Jensen Associates, Michael Pye, the Principal at Pye Associates, Richard Barnes, Senior Consultant of the Vinden Partnership, Kenneth Salmon, Solicitor at Slater Healis, and James Driver, Partner of the construction team at Clark Wilmot, with questions posed by myself, Matt Drake. We hope you enjoy listening. So I'm sat here today with Peter Vinden, who is the Chief Executive of the Vinden Partnership. Peter, do you want to tell us a little bit about your background and how you got here this part of your career?
Yeah, happy to do so. Well, the Vinden Partnership is a multidisciplinary claims advisory business. It's been going 25 years, but I think you're more interested in my background as an adjudicator. I've been adjudicating since 1999 when I was admitted onto the RICS panel. I was 36 at the time. I think I'm the youngest adjudicator that was elected onto the RICS panel. Okay. And really adjudicating for them and various other panels like the RIBA, TEXA, CEDA, what was the old Academy of Construction Adjudicators, ever since. And funny enough, I was actually looking at my records today, and I've done in the region of 317 adjudications over the last 20 years. So
wow, 317?
Yes.
Even if it was 317 is like still very impressive.
Well, it's a lot of adjudications, yeah. And that's just as adjudicator. Obviously, that's not accounting for party rep work.
Right, okay.
That I do from time to time. But these days, it's predominantly sitting as an adjudicator, not...
as a representative?
No, I mean, I've got a team of guys that do that. And the way we tend to advise clients is that one of the guys will act as your party rep. But if you want feedback on how an adjudicator might deal with a particular issue, they're free to come and talk to me, and I'll give clients a steer. In terms of qualifications, I'm a chartered quantity surveyor, so a fellow of the RICS, fellow of the Chartered Institute of Arbitrators, fellow of the Chartered Institute of Building. I'm also a fellow of the Chartered Institute of Civil Engineering Surveyors. And my working week is sitting as an adjudicator, an arbitrator, a mediate, or I'm doing quite a lot of expert determination at the moment, which is just another dispute resolution process. So
pretty much apart from running the company, your day-to-day involvement or your day-to-day work or weekly work is acting in a dispute resolution manner, in the sense of you're the resolver of the disputes.
Yes, full-time dispute resolver. That's a good way of describing what I do, yeah.
Would you have thought in 1999 that you'd be doing this full-time?
No, and just to give you an idea, in 1999, when the Construction Act, or the Housing Grants Construction Regeneration Act, really started kicking in 1999, I actually did one adjudication that year.
Right, okay. Just the one?
Just the one.
But I can imagine there wasn't that many in the first year.
Well, I think it was 1st of May 98 that it started.
The scheme came in then.
And I think it was the back end of 98 when I got my first appointment decision in 99. 2000, it went up to the heady heights of 2. And then it started progressively increasing year on year on year to where we are now, where typically 24, 25 adjudications a year is not unusual.
Wow, that's a lot of adjudications.
It is.
So the listeners today are going to get some invaluable information, aren't they, in that sense then?
I'm going to try.
Well, we can only try.
I know to do it wrong.
There's a lot of people like that, and I'm definitely one of those. So this theme of podcast concerns do-it-yourself adjudication. And last year there was a seminar that was put on by CIARB and CIOB.
Yep.
And one of the topics was, which you spoke about, was the notice and the appointment. So the notice of adjudication and the appointment of the adjudicator.
Yes.
And what the idea today then is to talk about that, for you to give the listeners of this podcast information on, obviously information which they can readily obtain elsewhere, but with your opinion on that particular process. So
yeah,
other people who I speak to in the industry, which I think is the tried and tested procedure, is get your referral written first of all, because that hones in on the issues, and then write the notice. And what is that? What do you share the same thoughts on that?
Well, in theory, it's a sequential process. So you start the adjudication by issuing the notice of adjudication. And if you read the primary legislation that underpins the adjudication process, that talks about a referral being served on the opposing party within 7 days of the notice being issued. And in the early days, what you'd often find is that parties would draft notices of adjudication, which is effectively telling the other side, we're going to take you to adjudication. And there were a number of cases where that happened, and potential responding parties came to the table and settled. So it wasn't unusual for parties to issue a notice, wait for 3 or 4 days, and then if they didn't get a settlement, rush to draft the actual referral notice.
Right.
And what can happen in those circumstances is that you draft the referral notice, or having already served a notice, you look back at what you've actually asked for in the notice, and I'll come on to that in a minute, and you realise that you've asked the wrong questions in the notice, or you've missed something.
Yes.
So I totally agree with what you're saying. I would never dream of issuing a notice of adjudication until I've drafted the referral, because the referral will bring into focus exactly what questions you need to set out in the starting gun, if you like, which is the notice of adjudication.
Right, okay, which, just picking up on something you said there, going back many years ago, people would issue the notice and hoping that would bring someone to the table. That is still a tactic today that people use, not necessarily in the sense of they've not already shaped what their argument is, but they try it on. They'll issue that as a kind of a mock notice to see if it does anything to get them to the table before starting that process.
And I understand it's difficult for a client that's contemplating running an adjudication. It's not a cheap process. They're probably thinking, well, hang on a minute, if I pay to have the referral put together, which is the most expensive bit, and then I issue the notice, and then the opposing party comes to the table and settles straight away, the thought process, well, I've just wasted a load of money on the referral notice. And I get that. But the downside is that if you issue your notice as a threat and you're not ready to start the adjudication, your bluff gets cold, then you've got two choices. You can either rush and try and cobble together the best referral you can in a couple of days, which I wouldn't recommend, or alternatively, you can let the notice lapse. You can let it expire and then issue another notice.
Right, okay.
The problem with doing that is you're losing credibility with the other side.
And you kind of already given them a bit of a preempting them of what you're actually going to possibly put in front of them, and that gives them longer to prepare their response.
Possibly, although I know we're not going to talk about crystallisation and jurisdiction issues per se, but we often will draft the notice, the referral notice itself, send the referral to the client and to the opposing party and say, look, we're acting for this particular client. We've been instructed to run this adjudication against you. Here is the referral notice. We're not going to serve you with the notice of adjudication yet, because we'd like to read it, consider it, and see if you'd like to speak to our client rather than starting the adjudication. And if you do that, there can never be any arguments about crystallisation, because the other side have had a damn good notice of exactly what the issues are and what you're going to want out of the process.
So that there can be, even if a client thinks, well, I've just spent a few £1,000s on this referral and we've settled, I've wasted the money. It's actually, they can take that view, but I don't think that is the correct view, because the purpose of that notice, which has been come out of the back of the referral, has actually got them to that point where they're able to reach a deal. So there's something positive that comes out of that process anyway.
The way I'd look at it is, for your listeners, the referral is the claim, the notice is just the starting gun. And my advice is you don't fire the gun until you're ready to run your race. That's the best analogy I can give you. And you won't be ready to run your race until you've drafted your referral. Your claim submissions are all ready. I think you're dead right. If you've done the referral, it will bring into focus what you want to get out of the adjudication. You'll know exactly what you're looking for. And that may well form the basis of any joint settlement discussions, without prejudice discussions, And look, if that gets it settled, that would always be my advice.
Yeah. Well, that's ultimately what they want, isn't it? They want a settlement. They want a decision. They want the dispute or the issue that's in front of them brought to a close so they can move on.
I think that's right. I mean, bear in mind that adjudication produces temporary and binding decisions. Let's not beat about the bush about this. It's highly and largely supported by the courts, and it's rare that decisions are not enforced. The theory is it's only of a temporary status.
For cash flow purposes.
For cash flow purposes. In reality, it goes a lot further than that. I think I don't mind sharing that with the listeners. I'm dealing with an adjudication at the moment over £5 million, where there's two parties, there are lots of issues, a whole raft of experts from different disciplines on either side. And I've said to the parties, look, this is costing an awful lot of money. Why are you adjudicating and not arbitrating? And they made it quite clear that they like the adjudication process. They're likely to treat the decisions final,
right? Okay,
which they're entitled to do, and that's the process that they want to use. So who am I to say you shouldn't be doing it?
Well, hopefully for the party that doesn't get out of that situation what they want, that they do take it as final, because it won't be uncommon for them to.
Well, unless I do something wrong, which I hope I don't, they'll be stuck with the decision on a temporary basis
until they go to
they rerun it again. And that, they've spent a lot of money on this matter, a lot of money. So I can't believe that they would quickly want to go off and run it again. And I think it would be court, actually, when I think about it. It wouldn't be arbitration, it would be a high court case. Right. But yeah, okay. Interesting.
Well, so in terms of the notice, or continuing along with the discussion on the notice, I think you possibly have, but just for the listeners' benefit, could you define what is the notice?
Well, okay. I mean, starting right at the basis, when you look at the statutory legislation where all this comes from, the Housing Grants Construction Regeneration Act, what that piece of legislation says is that a construction contract must have a provision allowing a party to give notice to the other side that they wish to have a dispute or a difference resolved by adjudication. So in its absolute basic form, it is just, I'm telling you, mate, we're going to adjudication.
Yeah.
Okay. Now, what the listeners may or may not appreciate is that every construction contract will have a mechanism that will define how the adjudication process is going to run. And I say that because even if it's a simple order that doesn't talk about adjudication, we have a set of rules called the Scheme for Construction Contracts that kicks in. If it's a sophisticated order on JCT or ICE conditions, the contract will contain a mechanism that will explain how the adjudication process is going to run. And where I'm going with this is there is always a prescribed mechanism that will describe how and in what form the notice should be issued. But if we take the Scheme for Construction Contracts, which is the default provisions that you would have if your contract didn't specify any particular adjudication rules, you would have to identify the parties, which might seem strange, but you need to clearly identify that it's you as Fred Bloggs Limited wishing to serve notice on J Mills, whoever it is, or whoever. It doesn't really matter. The notice has to identify clearly who you are as the claimant,
yes,
and who the opponent is going to be.
Okay.
And even better, if you can do it, if you can identify the company number.
Yeah, from company's house or correspondence from them.
You can get the company number off a letterhead, or failing that, if you do a Google search, this information is freely available on the web. And the reason why I often recommend putting the company number in is, strangely, you will often find that you can have companies with the same name that are different corporate entities. And the only thing that sets them apart is the actual company registration number.
Right, okay.
So, for example, if you take the name Mills, for example, there'll be many Mills contractors, Mills Contracting PLC, Mills Specialist Services. And what you don't want is an argument about who the adjudication is actually with.
Yes.
The way to avoid that is identify how the company is defined at Companies House, including the registered number, if you can do that.
Okay.
So that's the first basic. The second thing that you'd be obliged to do is explain what the dispute is about. It could be that we've put an interim application and you've not paid us. It could be that we've asked for an extension of time and you've not given us all our time. It could be an argument about a specification interpretation. You might be saying that this wall is built in accordance with the specification, and the other side may say it's not. So you have to say in the notice what is the dispute. You have to clarify what that difference is, and you have to set out what you want the adjudicator to decide. You need to tell him what questions you want him to answer. So, for example, you might think it is a given, but if you've got a dispute over an extension of time, if you just simply say, we'd like the adjudicator to decide that we're entitled to an extension of time of 5 weeks for variations or whatever, that's the question he's going to answer. So you can't, after the event, say, well, we also want you to decide what loss and expense is payable, because that question is not in the notice.
Right.
So it's only the questions that go in the notice that the adjudicator has what we call jurisdiction or power to actually answer.
Which is all the more reason about what we were talking about earlier, which is you'll determine the questions by setting your case out.
Absolutely.
And then you can get to the bones of, well, what do we want sorting out here?
Absolutely. And classic things that get missed are you forget to ask for an award of interest. You might ask for a decision that there has been a variation and you want that variation, the value determined by the adjudicator, but you forget to ask him, are you entitled to an extension of time as a result? Are you entitled to payment of loss and expense as a result? So it's not until you've drafted the claim and you've thought through fully exactly what you want that you can really go back to your notice and then hone down and define the list of questions that you want the adjudicator to deal with. And then you need to tell the adjudicator what remedies you want. So, for example, you might want the adjudicator to decide that an amount of money is payable by a particular date with interest, for example. But if you don't ask for a decision that payment is going to flow, you won't get it.
Right.
So I'll give you an example. You might ask the adjudicator, we've got a dispute over a final account. What is the value of the final account? The adjudicator can tell you, I decide that the final account is £100,000, but nothing flows from that because you've not asked the adjudicator
to do anything with that.
To do anything with it. So what you'd really need to do is say, we want you, Mr. Adjudicator, to decide what the final account is and what sum is due and payable to us under the terms of the contract, and any further sum that's due and payable in respect of interest, for example.
Right, and then then what arises from the decision is the amount and when it's to be paid.
Absolutely.
And interest. So there's no ambiguity about. There's no point having a decision to say the variation is £100,000. Well, thanks.
Absolutely. What flows from it? And you'd be amazed how many notices of adjudication that I see where, yes, I'm asked to decide that the value of an account is a certain amount or the value of the variation is of a certain amount, but nothing flows from that. Don't assume that the adjudicator will give you something, including a decision that payment is going to flow to you, unless you asked him for it. It's as simple as that.
So listeners who would be considering doing the do-it-yourself approach for the notice, I mean, they can get this information from, if it is a scheme-led adjudication, they can get this from part 1 of the scheme.
Yes.
And in there it sets out the parties.
It does.
Who you are, who you're against. It's important to put in there the company number, as you say, to avoid any differences of, that isn't our organisation, this is our organisation, so it avoids those ambiguities that you can get there.
Absolutely.
You want to set out what the dispute is, what the redress sort is as well, which is what we've just spoke about there.
Absolutely.
Is there any other points there?
I think if you are not sure what rules are going to apply, and what I mean by that, is it the scheme for construction contracts, which is the statutory rules, or is it the JCT rules, or is it the TEXA rules? you need to set out in your notice which rules you think apply.
Are applicable to the
Yeah, and you'll get those rules either by looking at the subcontract that you've signed or the order that you signed. They'll be in there. They should tell you what they are. If it's silent about what the rules are in terms of how the adjudication will be run, you're going back to the scheme.
Which has a comprehensive set, 25, 26 or something like that.
Yeah.
Rules that are all broken down about what the adjudicator can do or has the powers to do.
Absolutely.
Okay.
The notice for me is of absolute fundamental importance. I know this series of podcasts is on the subject of DIY adjudication, and there's nothing wrong with a party representing itself in adjudication, but I would urge parties, if nothing else, if they're going to take some advice on the content of the notice is critical. You can make mistakes in the referral, you can say inappropriate things at a meeting, you can get things wrong in correspondence, but what you can't put right are mistakes that are made in the notice of adjudication.
Would you advocate those DIYers, to call them such, to issue or seek advice from, say, a company like yourself and say, can you just cast your eye over this notice and give us some feedback?
For the sake of half an hour or an hour, you're going to save yourself an awful lot of pain and an awful lot of money in the process as well. And think about it, if you've done it once and you've got one notice of adjudication that's drafted properly and in accordance with the scheme or whatever, you're going to be able to use that format which you can adopt and modify for subsequent adjudications.
Yeah. So it's a good investment in any event, isn't it? For that one and future ones, you're going to be able to use that template again.
I think so. And as I say, it never ceases to amaze me how many notices of adjudication that I see that are deficient in some way, shape, form or other. It can be a real problem because it can stop me doing what I think the parties want me to do because I just haven't got the power. But I often see situations where parties start an adjudication, realise that they've got the notice wrong, they end up withdrawing the adjudication, they get a bill for that, and then they start again. So it's expensive to get it wrong. So
one of the things I wanted to ask about was what could go wrong, and just picking up on a few of the things you've said, I would say that it can go wrong if you don't actually request the adjudicator to say, for example, we're entitled to the £100,000.
Yeah.
Please make an instruction for that to be paid or a direction for that to be paid to us. So that's an area that can go wrong because there's nothing. Can you think of any other areas?
Well, going back to real basics, if you are in dispute with, let's say, a large PLC contractor, what you will find if you look on Companies House is that contractor is probably going to have multiple subsidiaries. They'll all have the same name, slightly different, but all have different company numbers. So you really have to identify who it is that you're actually in contract with, because of the number of adjudications that I've seen where the responding party is not clearly identified, and that puts a doubt in everybody's mind about who is actually responding to this. And what you don't want is a responding party right back and say, well, it's not us. They've got the wrong party. It's somebody else with this company number. You're going to look foolish. Your confidence is going to be dinted. The adjudicator is going to be thinking you don't really know what you're doing. Just sets the wrong tone. So identify who it is that you're going to adjudicate with, get it absolutely right, and as we've said, get the company number on the notice if you can. Think about exactly what the dispute is, so you can give a good brief description of what the dispute is. You need to say where the dispute arose, because that's one of the requirements of the scheme or a contract. And then you need to set out clearly what the issues are that you want the adjudicator to address, and what questions you want him to answer, and what relief you are looking for.
Yeah. Okay.
So it could be, I want a decision on that there's a final account. I want the decision that as a result of that final account, there's an amount of money flowing to me of X or such other sum, as the adjudicator might find is due and payable. Because if you only ask for one sum, you can only answer you're either entitled to it or you're not. So again, it comes down to refining the question.
Yeah, and get the wording correct, because that's a common thing that party representatives for the referring party will say, isn't it? Or such other sum as the adjudicator decides.
Absolutely.
So you're not closing. Yeah. It's an open question as opposed to a closed question.
That's an excellent way of putting it. You ask open questions. The more open the question, the wider the jurisdiction of the adjudicator is, and the more likelihood is that you're going to get the decision that you want. And it goes for time as well. If you think you're entitled to a 10-week extension of time, and you've only given 2 weeks, so the dispute is 8 weeks, you ask the adjudicator to decide, I'm actually entitled to an extension of time of 10 weeks or such other period as the adjudicator decides. Yes. Without those words on the end, arguably, you can only decide it's 10 weeks or nothing.
Yeah.
See the point?
Yeah, definitely. And I think that's a really good tip for the listeners. And just picking up on some of the points you've said there, it could, if they get the party, the responding party wrong, it can stop in its tracks at that moment in time. Absolutely. And they have to start again. If they've got that correct and they've got the dispute correct, they've got the contract correct, but they've not really set out the redress that they seek, they can go through the process. But if they've not got something in there which directs the adjudicator to make something flow from the decision, then they'll have a decision, but no other further action can take place.
Well, yes, and ridiculously, I've had situations on many occasions where I've had to run a second adjudication. It's come back to me again because the thing that they really wanted to ask me for, they didn't. So I might have decided what the final account is, but because they've not asked for payment, the other side haven't paid, and they come back and they say, please decide that such monies are due and payable, and then I deal with that as a separate dispute, and they end up paying twice. What's the sense of that? Not good.
Senseless.
Yeah.
Okay. So one of the questions I've written down here to ask was, what can be done to prevent it going wrong? And again, I'm just recapping here. I think take your time. If you're unsure, get a second opinion from a professional, and refer to the contract to make sure that you have got all of the necessary information, parties, project title, which adjudication rules apply. If it is the Texas rules or CEDA rules or whatever, then you follow those, or you make reference to those in the notice. If it's not and it's the scheme that applies, then set that out as well. So there's no ambiguity whatsoever for the person who receives the nomination about what they've got to comply with, what they're being asked to decide. They know who the parties are there any conflicts. The notice is massively important for the whole course of the process.
Absolutely. It's the start and it can be the finish of a successful adjudication. If you get it right, the adjudicator's got proper jurisdiction, he knows what's required of him, and so does the other side, and you'll get a binding decision. If you make a mistake, there's a possibility you could end up with a decision that's not enforceable, which nobody wants, or worse still, you may have to abandon the adjudication that you've started and start again. And those sorts of mistakes are expensive and should be avoided if you possibly can.
And the good thing is that it's actually in their control to avoid them, isn't it? It's they've got options available to them to avoid them. So it makes sense to take your time.
It does, but I often ask this question of clients that are thinking about drafting their own notice of adjudication. I have a vague idea how to build a garden wall, but I couldn't do it as well as a bricklaying subcontractor. We are drafting notices of adjudication all the time, so stick to what you know, and if unsure, ask for advice.
Yeah, I think it's a common trait in the construction industry. If people always think they can do it themselves, and I'm not to talk down the DIY adjudication, but they think they can do it themselves, and then they don't do it as good as the people who do it all the time can do, which is obviously the case. But if you were going to build a wall and you were adamant you were going to build it yourself, you might know somebody's a bricklayer. Can you just come round for 10 minutes, half an hour? And that's the same principle here, isn't it?
It is.
And I don't think that's... And we probably do that in our day-to-day lives anyway. We probably, if we were going to be cutting some timber at home, we might know somebody. Can you just tell us if I've got it set up correctly for the right angles? And then,
absolutely.
So there's no difference there.
No.
So moving on from the notice, after the notice has gone in, there's another event which has to take place. And I've got it down here as the appointment of the adjudicator. Because if you've issued a notice and you intend to get an adjudicator in place, you've got 7 days to do so.
Yes, and it's a 3-stage process. You issue the notice of adjudication. You then go off and you go to the relevant, and we'll come on to that, adjudicator nominating body who will select an adjudicator and nominate that adjudicator. And then you refer the actual dispute, you send the claim documents to that appointed adjudicator. Which nominating body you go to may be something that you can choose, or your contract might actually dictate who you have to go to. So it's not unusual for, in the case of main contractors, to set out in the standard orders and standard subcontracts that the nominating body will be the Chartered Institute of Arbitrators or whoever they choose.
Yeah.
So if you've signed up to a subcontract that says the nominating body will be the CIARB, you can't change your mind on that. You can't go off and approach the RICS or CEDA or TEXA. You've contracted with the contractor that the nominating body will be the CIARB, and if you make the mistake of going to the wrong nominating body, and the wrong nominating body will take your fee, by the way, will nominate another adjudicator, what you'll find is you'll get a jurisdictional challenge and your adjudicator will resign because he's not got jurisdiction because he's been appointed by the wrong nominating body.
That's quite critical. That's one of the key things for the person who is looking to appoint the adjudicator to get right. It's fundamental. If they go to the wrong body, it will automatically fall at the first hurdle.
You're absolutely right, but let's be clear about this. It's not the nominating body's responsibility to check that you've got it right.
They're relying on you, aren't they?
They would be relying on you having got it right. So you'll fill in a standard application form in which you will say, "Dear adjudicator nominating body, here's my cheque for £400 or whatever it is. Please nominate an adjudicator to deal with the dispute set out in the attached notice of adjudication." That's the sort of typical thing that you would see. Now, there are cases where the subcontract or the contract doesn't identify who the nominating body will be. And if that is the case, then you're free to approach any of the nominating bodies that you want. You can go to the CIARB, CEDA, TEXA, RICS, ICE. There's a whole raft of nominating bodies.
There is a website where if you were to type in adjudication nominating body, it will take you, I'm pretty sure it takes you to a site, and on there it tells you all of the nominating bodies. And
yes.
You can go and click on one of those, it'll take you to the relevant page of their website, and you can download the nomination form there.
Yeah.
I can't remember the name of that website, but the listeners could easily find that out.
Yeah.
And there are quite a few nominating bodies, and they all compete with one another.
They do, and what you might find surprising is that the RICS, for example, which is predominantly made up of surveyors, quantity surveyors and building surveyors, also have on their panel architects and engineers. The RIBA, which is obviously the architects panel, has quantity surveyors and engineers on their panel. I'm on the RIBA panel as well. And the reason why the panels have different skilled adjudicators on their panels is because when you fill the application form, and you will be given the opportunity to ask the nominating body whether they can appoint an adjudicator with particular skill sets. So you might say, "Dear nominating body, this is a dispute about the interpretation of an MBS specification, and we would like you to appoint an architect if one is available."
Yeah.
And the nominating body will try and comply with your special requests or special skills that you dictate on the application form. That's not unusual. What I would say to you is, if your dispute is one that requires, or you think it needs a quantity surveyor to determine that dispute, then ask for a quantity surveyor if you get that option. If it's one about specification or design, you might want an architect or you might want an engineer or a delay analyst. So think about what the dispute about is and what skill sets you want from the adjudicator, and put those skill sets on the application form.
Yeah, it is, not to talk down the skills of an architect, but if it's a quantum issue, you wouldn't necessarily go to an architect to get a decision on that. You would want a quantity surveyor to make a decision on that, wouldn't you?
I think that's right. But bear in mind, if you don't tell the nominating body what you want, they will just select whoever is available at the time.
Right.
And you might get an adjudicator that's not got the ideal skill sets. You'll still be able to answer the question, and still be able to deal with the reference in a fair and reasonable manner. But he may not have the attributes and skills that you are looking for from the adjudicator you had in mind. So it's your responsibility.
Yeah, I fully understand and hope, I don't think you could be any clearer with what you've said there.
Yeah.
So we know what the process is, we know what's important. I think we can understand what can go wrong, which is the adjudication stops in its tracks until you get the right nominating body down on the form. I think it's wrong to say that if you had a quantum issue and you asked for a delay analysis that that's a wrong decision. I don't think it is a wrong decision, but
no,
you want to try to be specific with the person. You want to decide that dispute based on the dispute to hopefully help you get the outcome you are seeking, the decision you're seeking in the notice and the referral.
Absolutely. It's perfectly legitimate for you to set out the attributes that you want from the adjudicator that's going to be nominated. You will often find as well, the forms will ask you to identify anybody that you think might have a conflict of interest. And what that means for your listeners is you don't expect to have an adjudicator appointed that you have a close proximity to, that that you do business with. That doesn't happen. And what you don't really want an adjudicator appointed that you've got any connection with, because what you'll find is that adjudicator will probably resign because he's got a conflict of interest.
Right.
And when I'm approached by any of the nominating bodies, they always say, here's the notice of adjudication, here are the parties, please write back and identify any conflict that prevent you from taking the appointment. And we have a system internally where I go back through all our records over the last 10 years to make sure there's not been a connection with either party. If there is, it may stop me from taking the appointment. So there's no point you asking for an adjudicator that you would like because you know him, because he's not going to be able to act. And even if he was daft enough to act, the decision won't be enforceable. So just no point.
The perception is that there would be bias from the adjudicator to the party that they know.
I think that's right. And the test of bias is not whether there is actual. Well, there is actual bias, but there can be what's called apparent bias. An apparent bias is where an independent observer looking at the situation would say, well, that doesn't look right. How can you have an adjudicator decide this dispute when one of the parties knows him really well, is related to him, has a business relationship with him, has engaged him in the past, all the sort of normal things you think, well, that just does not look right.
Yeah. It's common sense, isn't it?
I think it's common sense.
Correct me if I'm wrong, but are adjudicators guided by, is it the arbitration rules on bias, or do adjudicators have their own rules to consider?
There are all sorts of standards. There is a set of rules produced by the International Bar Association, which is like a traffic light system, which identifies whether it's safe for an adjudicator or an arbitrator, for that matter, to take a particular appointment. And there are clear red lights where you just can't do it. There are amber lights where effectively you tell the parties, look, I worked with this guy 5 years ago. Do you want me to proceed or not? And then there are green where the fact that you might have seen him in the supermarket at the weekend is not going to stop you from taking the appointment. And the RICS have a series of procedures to identify conflicts and how you might deal with them. The CIR have guidelines as well. We all look at these guidelines, but I once remember somebody I know and respect very well saying to me, look, if there's a feeling in your gut that it's not right, just don't take the appointment. And that's how I tend to work it. If there's anything a bit odd, I will.
It'll play on your mind, wouldn't it?
Yeah, I had a situation 12 months ago where I'd been appointed in an adjudication. I'd recognised the main contractor, knew the main contractor by name, didn't know who the employee was that the main contractor was pursuing in the adjudication. And about 2 days after I'd been appointed, I got a phone call from a very close friend of mine who was laughing and joking with me on the phone. He said, I didn't realise we would be doing the adjudication together. And I said, what are you talking about? He said, well, I'm a director of this employer. So, right, thanks for telling me. As soon as I got back to the office, I immediately sent a letter. So it's just come to my attention that a close personal friend of mine is a director of this particular employer. In the circumstances, if the parties wish me to resign, I will resign my duties as adjudicator, so you can go off and get somebody else appointed. And because I've been open about it, both parties wrote back to me and said, "Sir, we're perfectly happy that you've disclosed the connection. We'd like you to continue." And I did.
That's good. That's good, isn't it?
But it was their choice. If either of them said we're not comfortable with this, then I would have resigned. And interestingly, I wouldn't have taken the appointment to start with had I known.
Yeah.
It was only because I found out afterwards that I could give the disclosure and then offer to resign.
They probably appreciate the honesty, don't they, really? I think that's
there's no other way to be.
Yeah.
It's a judicial process, and you can't allow anything to get involved in the process that would taint the outcome or the process itself.
Yeah, it's a purely objective process.
Absolutely. Yeah.
Oh, okay. So I think we've covered the notice and the appointment in some detail there. I suppose just if we can have a brief chat about jurisdictional challenges, which can come about through issues with the notice and issues with the appointment. That would be good for the listeners as well.
Yeah. There are two types of jurisdictional challenge, and I think what you're alluding to is what we call threshold challenges. These are challenges that are made by a responding party immediately after the adjudicator has been appointed, usually because there's something wrong with the way he's been appointed or there's something wrong in the notice. So give you some examples of how I've reached the conclusion I've not got jurisdiction and resigned. The classic is that an applicant, a referring party, has gone off and got an adjudicator nominated by a nominating body either before he served the notice or at the same time. The Act makes it clear you serve the notice and then you apply to get an appointment. But you'd be amazed how many people get it the wrong way around. That's one. Going to the wrong nominating body. So you might have a contract that says your nominating body is the CIR and they go off to the RIBA. That's a fundamental problem. Once you've been nominated, the referring party is obliged to serve the referral within 7 days on the date of the notice, the service of the notice. And you'd be amazed how many times I've had referrals that are come in late. I'm challenged by the other side. You might think, a couple of hours or a day, it shouldn't make any difference, and it might not make a difference, but would you really want to run an adjudication and take that chance? No. When that happens, I usually say, look, you're better off starting the process again.
Yeah, definitely.
Or I will invite the responding party to say, look, think about withdrawing the challenge, ask the responding party to withdraw the challenge, but ask for more time to serve the response. And you usually will get common sense. But if in doubt, get it right, stop it and start again.
Yeah, I remember a situation arising where somebody had issued a notice of adjudication 3 o'clock, and 4 o'clock they issued the appointment to the RICS.
Yeah.
The next day, the responding party said, "Oh, we've been contacted, or you've appointed, or asked an adjudicator to be appointed before you've served the notice," and it was all via email, and it was just a clear tactic because there was proof that the notice had been issued via email, and the appointment had gone, at least an hour later, but they couldn't prove it because there wasn't any delivery notes or read receipts. I think they were using a different format, an email format, Mac or something like that, and they couldn't prove it, so they ended up just stopping it and starting again.
Yeah. Well, normally if you're using Outlook, for example, you will normally get a date stamp on the issue of an email, and if you can prove, so if you prove to me that you'd served a notice at 1 o'clock in the afternoon and then you'd applied for an adjudicator at 2 o'clock in the afternoon, or even 1:15, I would be happy with
the delivery,
provided I could see proof that one followed the other. If there's any doubt, I'm just going to be inviting trouble, and I would probably suggest, look, start the process again. Yeah. I don't want to run an adjudication and give you a decision that might not get enforced because the appointment is wrong. Other examples, you can have difficult situations where I've had this, where a subcontract will actually identify 2 nominating bodies in 2 different locations, where the contractor cocks up, so it's unclear who the nominating body is, and then you get into arguments about, well, it's not clear, is it the scheme? Is it the RICS? Is it, in those sort of circumstances, I will often go back to the parties and say, look, do you want to agree who the nominating body is going to be? Because, and this is really important, if take myself, for example. I'm on the RICS, I'm on the RIBA, and I'm on TEXA. Okay. So it's possible that any one of those three organisations could appoint me. But if they are not the nominating body that's in the contract, my appointment would still be invalid. So if the contract says the RIBA appoints adjudicators, and I've been appointed by the RICS, okay, and the responding party is a wrong nominating body, it should have been the RIBA, you can't turn and say, well, it doesn't matter because Mr. Vinden's on the RIBA panel as well. It's still wrong. Yeah. And I will still resign in those sort of circumstances.
Right, okay. So the ultimate is to avoid jurisdictional challenges.
Yeah.
You do get them. I'm pretty sure every single one you must be getting a challenge.
I'd say certainly 1 in 2, possibly more, possibly 2 in 3.
Right.
You'll get a threshold challenge to your jurisdiction. Not always, but pretty much in the main. And I have the power to look at them and consider them. And I can make a ruling which is non-binding. So if I make a decision that I've got jurisdiction and I didn't have jurisdiction, then it doesn't matter what happens with my decision, it won't be enforced.
Right.
Because my appointment was invalid in the first place.
Right.
The good thing about threshold challenges is they are normally fairly clear. I have a sort of rule, if it's grey and I'm not sure, then I put it back to the party and say, look, I don't think this is crystal clear. Do you really want the cost of an abortive adjudication, or do you want to agree my appointment, or do you want to stop it and go off and get your right? And 9 out of 10 companies, they don't want to waste resources, so they'll cooperate with you in those circumstances.
Okay, all right, okay. Well, I think just coming towards the final bits of the podcast then, I have been and will continue to ask the interviewees one bit of advice that you would give, and it can be commercial, it can be contractual. What would you give to the listeners if you could give them one piece of advice about their involvement in the construction process, what they do and what would help them out?
What generally?
Yeah.
For me, you need to avoid disputes, and disputes always start with the subcontract order. So whatever you do, when you get that piece of paper, that subcontract that is sent through to you, you must read it, consider it, understand it. If you don't understand, go and ask a friend what it all means. But you must make sure that what you are contracted to provide because of the order is what you intended to provide.
Yeah.
Because it's not unusual that you think you've entered into a contract, keep it simple, to design and build and deliver a fridge, and what you've ended up with is an order that requires you to design, build and deliver a fridge freezer, which is something different. The fact that you've got it wrong is not going to protect you, so make damn certain that you look at what the order
I think a lot of subcontractors, they really want the work.
Yeah.
And I do lots of contract reviews myself, and what they want from you is how can we manage the process as opposed to already starting off, because they perceive that they're already being aggressive to the contractor who's employed them if they seek to have the contract changed, and they'd want to avoid that because they want the work.
No, I understand.
And often it's a case of, well, just point out what I need to be aware of, and can you point out and tell me what I should do? And certain things is make sure your applications are in on time, and make sure you send them to the right address or the right email address, and these are the things that jump out.
Yeah.
People fail to do, but they don't always want the contract changing because they're worried about not getting the work.
No, I understand that, but 2 bits of advice I'd give on the back of that observation. Number 1, if you identify at the outset that somebody's trying it on with you, you're sending them a message that you know what you're about, and they're less likely to pick on you. Yeah. That's the first thing. And the second thing is, depending what the extent of the problem is, you may not want that contract. Yeah. Because if you've only got a price in for a fridge and you've got to give a fridge freezer,
you don't. Yeah.
You haven't got the money.
You're never going to fulfil it, are you? You can't.
You're going to be on the back foot from the start, and you don't know. But the person that's drafted that order may have made a mistake. They may be grateful that you say, "Look, classic is you price one. Your price is compiled on one set of drawing revisions, and by the time the order comes around, those drawings have been superseded with construction issue drawings." So your price that you originally put goes in the order, but all of a sudden the construction drawings are being listed as well.
Yeah.
So all those changes from tender to construction are deemed to be included in that price. Now, being cynical, it might be an attempt by a contractor to stitch you up and get something for nothing. It might just be a genuine oversight and mistake. They didn't realise that the price relates to a different set of drawings. 6
months down the line, the QS who's issued the order could have moved on to pastures new. You've got a new QS in.
Absolutely.
Well, no, that's what you've signed up for. That's what we're working to. And
well, the general rule is that you don't look at documents that are issued pre-contract. You can't rely on pre-contract documents. There are some exceptions, but I don't want to confuse your listeners. But generally, you're quite right. Assume that a QS that's not been involved in the tender process will pick that order up and say, right, your price is £100,000. It's clear these are the drawings that you are contracted to deliver on, and if they don't match up, because you've not checked it, that's tough luck on you.
So check the terms, check for scope creep, and deal with it immediately.
Absolutely.
Brilliant. Well, thanks for your time.
My pleasure.
It's been very insightful. I'm very sure that the listeners of the podcast will get a lot of knowledge and great benefit from speaking.
Okay, thanks
a
very much.
lot.
Cheers.